If you're planning to apply for an e-visa as an investor or as a treaty trader, this video is for you. Some interesting changes are happening at the moment from the State Department when it comes to e-visas, E1, E2, as well as E3 visas for Australians. So we'll talk about those changes, what it means for you, and how it's going to impact your application when you come to the United States, specifically changes for dependents if you want to bring family members, as well as the amount of investment that you're required to invest. Hello everybody and welcome back to Immigration Channel. This is where we explain complex immigration matters in short, simple videos. We make immigration easy. And in this video, as I mentioned before, we'll explain some changes that are happening to the e-visa regulations that are coming from the Foreign Affairs Manual. Those get changed once in a while, and now we have some changes that require your attention. If you're applying for an e-visa, if you have currently an e-visa, whether it's an E1, whether it's an E2, and even some mention for E3 visa, specifically when it comes to dependents. If you bring family members with you, you need to listen to this video and share it with those people that need to know. So, before we do that, if you're here for the first time, don't forget to subscribe to our channel, click the notification bell so you don't miss any of our videos, and also give us a big like so YouTube will be able to show this video to more people just like you. So the e-visa rules are governed by the Foreign Affairs Manual. This is a guide issued by the Department of State where all the rules concerning to treaty investors, treaty traders are included in that guide. And that's how we get the regulations to know how much money you have to invest, how long those e-visas are going to be given for, and so on and so forth. That's how we prepare those E2 visas. We go to the FAM, we look at the guidelines, and we structure our clients' cases to meet all the requirements to ensure our clients' approval rate. Now, the recent changes are impacting a few important things. First of all, they're talking about the Substantiality Test. So as you know, when you apply for an E2 visa, you have to prove that the investment that you are putting into your business is substantial. Substantial is not a set amount, but it has to be reasonable for your business. Now, when you apply for an E2 visa and the officer determines that your amount is substantial and you're given that E2 visa, what the new rules are saying is that when you're going to renew this E2 visa in the future, you don't have to prove again that the amount that you invested is substantial. This only changes if the business changes ownership. So let's say you sell the business, somebody else is taking over, and they're also going to be applying for an E2 visa. They obviously going to have to reestablish the substantiality of their investment. But if it's your business and you're just going to be applying for extensions, you don't have to prove anymore that the amount that you invested is substantial if it was already established for the first time when you got your e-visa that it's substantial. Now, it's really important because a lot of companies are going through growth cycles. Sometimes they have more or less money. Sometimes things are hard. And it's always difficult to renew those E2 visas if we always have to reestablish the substantiality of the investment. This is going to make it much easier and makes more sense to help investors to continue to work on their businesses and be able to stay in the United States without fear of not being able to renew. So that's a really good change. Now here's what the problematic changes that were just introduced. And this is specifically for dependents. And this change, essentially what it does, it distinguishes between derivatives. So for example, your spouses and your kids that are from a treaty country. For example, if your E2 visa is from Canada and your family members are from Canada, then you are derivatives from a treaty country. Between derivatives from a non-treaty country. So for example, if the principal applicant is from Canada, but the wife and kids are from, let's say, Ghana, which is not a treaty country, they're going to make a difference into the duration of how long you're going to get visas. And I'm going to give you some examples to explain how it's going to work. And so under the previous regulations, the rule said that the principal applicant and derivatives get the same amount of time on the E2 visa. It doesn't matter whether they are from the treaty country or not. This is changing right now. So for example, let's say you're a Canadian applicant, you're the principal Canadian, and your spouse is also Canadian. You both are going to get your E2 visa for 5 years, the maximum duration. Let's take another example. The principal applicant is Canadian, but the derivative spouse is from Brazil. Once again, both you're going to get 5 years because Brazil is not a treaty country, so your spouse will get the same amount of time that you're going to get, 5 years. Let's look at the third example where we can see the change. Once again, principal applicant is from Canada. Now the spouse is from Israel, right? So the principal applicant is going to get 5 years, but the derivative spouse will only get 2 years because Israel is a treaty country and Israel can only get 2-year E2. So you see what they're doing? They're essentially saying that if your spouse is from a treaty country, they're going to get E2 depending on how much length of time their treaty country is going to get, which is going to be annoying and frustrating because some of these countries are giving less visa time. And so if you're married to somebody, for example, let's say from the UK, which can get 5 years, and you're a national of France, they can only get 2 years or 3 years, you're going to get the less amount of time depending on your country of nationality. Now, if your country has no treaty, you'll be fine. You'll get the same amount of time just like your spouse, which again is unfair in my mind. The last change applies to E3 visa applicants. If you're an E3 visa applicant, you now have to be careful because you have to demonstrate your intent to depart the United States at the end of the E3 visa. This was not a requirement before, but it is a requirement right now, and I can anticipate some applicants to have issues with that if they're not going to be considerate and thinking about what they have to show the embassy to prove their intent to depart. So there you have it, some quite interesting changes specifically impacting spouses and family members of E2 visas. Remember, this is a very important change, and be mindful of that as you plan your application for an E2 visa. Once again, if you need help with your E2 visa or your E1 visa or your E3 visa, you know what to do. Send me a text, 619-483-4549. I'm here to help you. Thanks for watching, and I'll see you in the next video.